Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Things are going to be looking and sounding a little bit different for a couple of weeks because I'm traveling. Right now I'm in LA, and I do have a camera, but I didn't set it up. So you're not actually going to see me during this video, but I will have it set up for later on. We had an update this morning to the docket by Jennifer Abel. She's filed an opposition to Stephanie Jones' motion to dismiss the amended third-party complaint. We've already seen a lot of it, so I'm just going to go over some of the more interesting points. But as a reminder, I'm also doing my race with Omar this afternoon. So if you haven't seen it yet, we got this all set up. I'll put a link in the comments below. But 60% of the money we raise is going to go to the charity for the winner, and then 40% is going to go to the other person's charity. We're also going to do a couple of other things, but we haven't quite nailed that down yet. But we'll go live on his podcast this afternoon when all that's happening. I don't think we're going to be live streaming any swimming in case there's any accidental body parts. You know what I mean? We'll film that part, and you may or may not see it later. But the rest of it you can watch. I mean, I don't think anybody really wants to accidentally see an ass crack, so I'm kind of doing you a favor with that one. Anyways, on to this document. It's in regards to the indemnification claims. Unable to counter Abel's well-pleaded allegations, which must be deemed true and which are entitled to all reasonable inferences, JonesWorks improperly inserts its own so-called factual allegations into the motion, sometimes mischaracterizing Abel's allegations, sometimes citing the pleadings of other parties, such as Lively, and sometimes citing nothing. Substantively, JonesWorks erroneously argues that the 2021 employment agreement itself precludes the first cause of action for statutory indemnification under the California Labor Code. However, under the law of California, where Abel was employed, the 2021 employment agreement is null and void because it contains a clause contrary to the California Labor Code. In turn, there is no contract that bars her claim for statutory indemnification. In the alternative, and even assuming the 2021 employment agreement is not null and void, its choice of law clause does not extend to Abel's first cause of action for statutory indemnification under the California Labor Code. By its own terms, the choice of law clause is applicable only to the agreement and the performance of the parties' obligations hereunder, and therefore does not reach the performance of JonesWorks' non-contractual obligations, such as those under California statutory laws regarding indemnification. With respect to the second cause of action for common law indemnification, JonesWorks' argument is devoid of any legal basis, although JonesWorks contends without any legal authority that the indemnification clause in the employment agreement somehow supersedes Abel's common law indemnification rights. The well-settled New York law is that a contractual indemnification clause does not preclude a claim for common law indemnification. As for JonesWorks' alternative argument that the third-party complaint fails to adequately allege a common law indemnification claim, the pleading sufficiently alleges that the conduct about which Blake Lively complains consists of regular public relations activities by Abel on behalf of Wayfair and Baldoni during the time that they were clients of JonesWorks, a public relations firm, and undertaken at the direction of JonesWorks. Those facts must be accepted as true. Similarly, in support of the third cause of action for contribution, the third-party complaint contains multiple and detailed allegations that JonesWorks was ultimately responsible for any public relations actions that purportedly damaged Lively. Those facts, too, must be accepted as true. The motion should be denied in its entirety for these reasons, which are more fully discussed below. And we've already heard about these employment agreements kind of ad nauseum, so I'm not going to go over too much of this. Here they write, Lively's allegations against Abel, the veracity of which Abel disputes, are of conduct and communications directed at the press and the public to garner good publicity and to eliminate or minimize bad publicity for the clients Wayfair and Baldoni, activities which are the very essence of the public relations profession. JonesWorks and Jones gave Abel directions to carry out the duties of a competent public relations professional on behalf of clients Wayfair, Heath, and Baldoni, including but not limited to garnering good publicity and eliminating or minimizing bad publicity for them and their film. In addition, Jones personally interfered with Abel's competent handling of her duties, including by attempting to insert herself with poorly timed, negative communications to the press and public that were discovered by Lively's own publicist, Leslie Sloan. Jones' blunders clumsily disrupted a putative truce with Sloan by communicating negatively with the media about Lively, exacerbating negative press and public attention on Lively by adding fuel to negative stories of a feud with Lively. Jones' incompetent handling of communications with the press only caused negative stories to circulate further and attract greater attention. Abel was named as a defendant in Lively's pleadings only because of, and in direct consequence of, Abel's discharge of her duties as a competent public relations professional employed by JonesWorks. Here they're saying the court should disregard JonesWorks' improper factual allegations Jonesworks improperly cites Lively's amended complaint to introduce alleged facts in support of the motion. However, when determining whether allegations in a third-party complaint can withstand a motion to dismiss, the defendant/third-party plaintiff is not deemed to have admitted the allegations in the main action's complaint. To the contrary, the allegations of the initial/underlying pleading are irrelevant. None of Lively's allegations can be considered on this motion. Furthermore, Jonesworks routinely cites Abel's amended answer to Lively's amended complaint and to Abel's amended answer to Jonesworks' complaint. Even assuming the court takes judicial notice of Abel's other pleadings, the court should not consider the spliced and/or cherry-picked communications that Jonesworks attempts to spin into factual allegations. For instance, citing to paragraph 76 to 86 of Abel's amended answer to Jonesworks' complaint and pasting parts of what are alleged to be text messages into the motion, Jonesworks misrepresents to the court that Abel admits that she actively worked to undermine Jonesworks' reputation. A basic review of Abel's amended answer shows that, in response to paragraphs 76 to 86, Abel either denied the allegation and/or merely admitted to sending the referenced communication and denied that Jonesworks' pleading had accurately characterized the communication. As another example of Jonesworks' deceptive conduct, citing to paragraph 33 of Abel's amended answer to Lively's amended complaint, Jonesworks claims that Abel developed and executed a smear campaign to bury and destroy Lively. In truth, paragraph 33 merely admits that Abel sent a communication and specifically denies that the communication and their context are characterized accurately in the complaint. In sum, the court should reject Jonesworks' efforts to mischaracterize Abel's factual allegations. Abel has sufficiently alleged that her actions were within the scope of her employment and in furtherance of Jonesworks' business. It is the general rule that an agent is entitled to reimbursement for payments made from the agent's own funds for necessary expenses incurred within the agent's authority in order to consummate that which they are employed or directed to do by the principal. An agent, compelled to defend a baseless suit, grounded upon acts performed in his principal's business, may recover from the principal the expenses of his defense. The third-party complaint alleges that Stephanie Jones' public relations blunders and incompetent handling of communications with the press only caused negative stories concerning Lively to circulate further and attract greater attention. Hence, the court should not give weight to Jonesworks' improper factual allegation that Abel went rogue. Jonesworks incorrectly argues that Abel's vague allegations failed to establish any plausible cause of action that Lively would have against Jonesworks, let alone one that contributed to the same injury underlying Lively's complaint. However, Abel's allegations are anything but vague. In over a dozen detailed paragraphs, the third-party complaint explains that A. Lively's claims against Abel for aiding and abetting harassment and retaliation, intentional infliction of emotional distress, false light invasion, and civil conspiracy all arise out of a so-called public relations campaign against Lively. B. Jonesworks directed Abel to provide PR services to Wayfair and Baldoni, including in a fashion that garnered good publicity and eliminated/minimized bad publicity for them in the film. And C. Based upon the foregoing, Jonesworks contributed to the same alleged injuries about which Lively complains. So like I said, a lot of this was just stuff we've seen before. This was the opposition to Stephanie Jones' motion to dismiss the amended third-party complaint, so it was pretty similar to the last one. That's all I got for now, guys. Thanks for watching, and I'll see you all soon.